Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hello, I'm Angela Princewill.
And I'm Sherine Abdi.
And our topic today is imputing income. It's a continuation of our last podcast where we had talked about imputing income, but we focused on intentional underemployment or unemployment. For further context, imputing income is governed by Section 19 of the Child Support Guidelines, so whether federal or provincial. And I know Shireen had kind of gone over what imputing income is in the last podcast, I think. But anyway, I'm just going to have you do that again. So, what really, when we say imputing income, what does that even mean?
It really just means that the income that you're presenting is not a true reflection of your income, and so therefore, because of multiple reasons, which we'll go over today, along with intentional underemployment or being unemployed, that your employment could be deemed higher.
Your income, you mean?
Sorry, your income can be deemed higher than it actually is by the court.
Yes, and really that's all we're talking about. And so there's enumerated factors in the child support guidelines that can kind of guide the reasoning as to whether or not imputed income is appropriate in the circumstances. So since we already talked to death about the intentional underemployment, let's talk about the other factors. So what I'll do is I'll just kind of list them out, and then Sharon and I will take them one at a time. So one is that a spouse is exempt from paying federal or provincial income tax. The spouse lives in a country that has effective rates of income tax that are significantly lower than those in Canada. It appears that income has been diverted, which would affect the level of child support to be determined under the guidelines. The spouse's property is not reasonably utilized to generate income. The spouse has failed to provide income information when under legal obligation to do so. The spouse unreasonably deducts expenses from income. The spouse derives a significant portion of income from dividends, capital gains, or other sources that are taxed at a lower rate than employment or business income, or that are exempt from tax. And the spouse is a beneficiary under a trust and is or will be in receipt of income or other benefits from the trust. So, yeah, if you got any of that, you're really good. So let's start from, imputing income because the person is exempt from paying federal or provincial taxes. Can I just say this person is just like really lucky?
Yeah, I mean, absolutely, right? Because you have to factor in the fact sometimes like there are child support payors that don't live in Ontario, or if they do, for example, paying federal or provincial tax, being Indigenous. But let's say it's a different example where someone is in a different jurisdiction, such as, in the UAE, where we know that they don't pay taxes. And so we need to factor in the fact that they're receiving their tax, of course.
Or their income tax rate.
Their income tax rate, yeah.
Yeah. Okay, absolutely. Because and if you wonder why that matters as well, it's because the guidelines already factor the guidelines provides tables that sets the base amount of child support that's payable, and that already factors in people having to pay a certain amount of taxes on their income. So if they're not paying those taxes, then their income would need to be grossed up. So in this example, the income imputed is really more of an attempt to gross up the income because it means they're not having taxes deducted from their income and all of that. So okay. Next one, the spouse lives in a country that has effective rates of income tax that are significantly lower than those in Canada.
Yeah, that's a good part. So, for example, if you live in the States or different parts of, I'll call it the States, they'll have lower income tax rates than here in Canada. So it would be I mean, depending on the circumstance, it would be appropriate to factor in, the benefit to that payor when calculating child support.
Absolutely. And this is almost like the reason we just talked about earlier as well. It's the same thing, the guidelines contemplate you paying taxes at a certain rate, right? So if you're making 100,000 and they're imagining that your marginal rate is 29%, and that's not tax information. By the way, I'm just throwing out numbers. It means the net amount you have is X amount of dollars, and so the table sets your child support or fixes your child support based on the expectation that you have a certain net income. So if you are not paying any taxes at all, and you're paying less than a person will, then that's an issue. And something I should add here actually with the table is it reflects the reality of different provinces, right? So the child support guidelines is created, the amounts are different. So a person, a child in Alberta would be receiving a support amount that's different from a child in Ontario because the effective tax rates in the provinces are different. And
the cost of living is also different, so the child support guidelines would account for
all
really
of
all
those.
of that.
And I know people often, and this is a very sticky one for a lot of people. People already for most people, the net income they receive is hard enough to live by, right? So you're making, I don't know, 100,000, and then you're taking home 70. I don't even know if you're that lucky, but we're just doing our numbers here, so let's do that. And so for a lot of people, by the time they have to pay the rent that we're seeing these days across the GTA and your car payments, there are still student loans for some people that are making that level of income. For a lot of people, it meant years of education to get there. So when you factor all of that in, to tell them to now pay a certain amount of child support from their net income, they think we're making a mistake.
Their gross income.
Yes, perfect. That's a very perfect way to put it, actually. I like how you put that. So we're telling them to pay based on their gross income, but they're only getting their net, and it's from their net that they're going to pay this child support. And I would say 9 out of 10 clients think we're making a mistake sometimes.
Yeah.
They would often tell me, oh, what I get bi-weekly is X amount of dollars, thinking I made a mistake by using their
And they're just, I think, surprised, how the system works, just because it's deemed as unfair. It's not factoring in my cost of living. It's not factoring how am I supposed to live if I pay child support. Trust me, if you could not afford to pay child support, the calculation would tell you.
I don't know if I could trust you on. I don't know if I could trust you on that one. Because I literally.
But the reality is
I don't know. It might not be undue hardship. It's just a lifestyle change, and it's interesting because I literally had this conversation today, and my client is just going through the numbers again. How does it add up? And was wondering if we could bring it up in the context of emotion that's coming up on the matter. And I think what I said, and again, I'm known for being straight up with my clients, so that I always have that relationship. And I said, the courts don't care if you have to no longer rent your home. So then where would I see the kids? I don't know. You might, the courts don't care. You could be homeless. You could maybe get a 1-bedroom and all 3 of you, sleep on air mattresses. It seems callous, but the amount is fixed.
Yeah.
And
the obligation is priority first to the children.
Yeah, and you mentioned undue hardship, and undue hardship is a very high threshold to meet as well, right? Most people don't. The courts would look at the table amount, the income exists. You have to deal with things. It might mean no more wines for you. It might mean you have to maybe bike more and save money on gas. There is a lifestyle change. So I think what I'm trying to say is I recognize that there is there's some level of hardship there. It's hard to make the numbers work, and I understand. But the tables are the tables, and you will have to make adjustments in other areas, but child support is kind of non-negotiable that way. So let's go to, and then as the next reason, and this one is, it appears that income has been diverted, which would affect the level of child support to be determined under the guidelines. Okay, whatever. You diverted income. It's just so long.
Yeah. I think maybe I'll illustrate it by an example. I had this recently come up. So I had a client who owns a corporation with her father, but she diverts the payments to her father as an employee. So he's essentially the only one being paid from the corporation, and she's not. So,
Yeah.
or another example is if it usually happens in the context of like most self-employed individuals that have the ability to divert money to maybe sources that they don't want people to know, so they don't get a true determination of their income. I think that's the simplest way I can explain it.
Yeah.
Maybe you could do better.
No, I think you got it. Even I'll just add another example, which is just say spouses, for example. So if the payor, if the support payor has repartnered, then you could just pay your spouse, and then
That's even more.
you might even be very.
Example,
it's so common. Like if you were capable of earning 100,000, then you split the income. Now your household still gets 100,000, but the new spouse is absolutely unconnected to the corporation, doing nothing, but your support is now based on 50,000 rather than the 100,000.
And that also ties into like maybe your tax rate as well, because you're diverting income, so you pay less taxes.
Yes.
Yeah.
Yep. All of that. So in those circumstances, if your books are being reviewed, which would be typical where support is a contested issue, I notice that here it says if it appears. So no one needs to prove this beyond a reasonable doubt, right? This is not criminal law, it's family law. They're not trying to get you for tax purposes. They're really just trying to make sure that as much money as possible flows for support. The other reason income is imputed is the spouse's property is not reasonably utilized to generate income. Has that ever happened to you?
Yeah.
Yeah.
For example, like, if you're dealing with a party that's now received an equalization payment, and it's a significant sum, and, they haven't used those funds to, put into assets that are income generating. So they've effectively not generated income when they've had an ability to do so. When they can, they just don't want to or have not, and not being reasonable about it. So, you have an obligation to be self-sufficient, and you also have an obligation to make sure that you're using as much, or if you have income generating assets and that you receive from like an equalization payment, you have to be mindful that those resources should go to increasing and generating more income.
Yeah, I wish I could say I've used this section in a different context, but I think that's the same way I've used it. It usually comes up for me when we're trying to vary. I think I've only used them in the context of varying spousal support, and how I've used it in the past is if my client's being asked to pay more, that's always a question I raise, right? I'm looking at RESP, or even sometimes people park money in a TFSA, and hey, I'm no investor, but there's a reason why I'm a lawyer. So, what if you're parking your money in the TFSA that's not generating any income for you, that's great. But when you're asking someone to increase their support, then the question becomes, well, there's high interest yielding GICs, for example. Why didn't you put this money in a bond? And my go-to would be to get an actuary or some other financial professional that can give me sort of a calculation of how much year over year you can get while still protecting that asset, right? So, yeah.
I mean, a TFSA is just, at least it's generating we hope, some form of interest. Don't put it in your checking account.
Yeah.
That there's no interest.
And you're paying back fees, bank fees.
Don't do that.
Yeah. So I think that the idea that there is, if you have assets, and it may not even let's not give the impression that it's only assets that you get through equalization. If you received severance pay, for example, early retirement payouts, whatever, when we're looking at all of your sources of income, you may still be employed, but then if there's money sitting somewhere that you could use in increasing your income, and again, as I said, I use this mostly in the context of varying support, then would look into that. So do be financially responsible with your monies, otherwise you could find income being imputed to you in those circumstances. Okay, so next one, the spouse has failed to provide income information when under legal obligation to do so. I love this one.
This is the most, I think, out of all ends here, like this is the most
Yes.
utilized one, and honestly the most common. So in a situation like this, so for example, let's say, your spouse, you've now been separated, historically your partner's made, or you've been privy to the fact that your partner's made, $60,000-$70,000 and just refuses to provide income disclosure. So in that case, you essentially would put forth the obligations that he has a financial, or he or she has an obligation to provide their disclosure, and when refusing to do so, the court can impute income to you at either the level of income that you've been earning or what they believe based on the evidence that's put before the court.
Yes. I have actually even gone on LinkedIn in the past and seen what people in similar positions are making.
Yes.
And
ought to be making.
Yes.
So if there's a capacity issue and someone, has the ability to earn income, and then you find comparables, and, you don't know what the actual income of the person that you're dealing with is, so you can estimate based off, similar situations.
I had a support payer, and in this case I was acting for the ex-wife, and the payer had repartnered the spousal support obligations that are being looked at this point, and payer makes absolutely no money. So in this case, the wife, who is now the owner of their rental properties that are income generating, is just the one that's making money, and now support payer is just so broke, makes no money. But then you look at his LinkedIn profile, he's part of these financial organizations. He's speaking at these events, and so again, how much could you make as a speaker? And it's not impossible that the speaking engagements were volunteer. I do a lot of speaking myself. I don't get paid for it. So, but again, when you're not providing income information, it would not be unreasonable for someone to say, well, if you were speaking at these events, what's a reasonable amount that you would get paid for doing that sort of work, right? And taking everything into all of those factors in, looking at their qualifications, what a person with their training would earn, we were able to get reasonable income imputed. And you know what I find that's interesting? You could follow up 100 times with a person to provide disclosure regarding their income. They don't. And then when a court makes a support order based on what they think is a reasonable income based on the evidence that you've provided, then the person turns around now and wants to change child or spousal support, right? Now they want to be involved. And just do be very careful, because it's not easy to change imputed income, especially say in the context of child support, for example. So if you're making $50,000 and you don't provide disclosure, and we succeed in getting your income imputed to $100,000, it just means that the year after that, don't come saying, well, this year my income's $40,000, so let's vary child support. It may not work like that. You may just find you're most likely going to be stuck on that imputed amount of income until a court changes it. And courts really don't like that, because they would give you lots of opportunities to provide your disclosure. And if you don't want to be part of it, it's pretty hard. You might be successful changing your income going forward, but to retroactively change it saying, well, I never made $100,000. Here's my actual income. It was 50. It's going to be hard. Nothing's impossible, but it will be hard to do, right? To reduce that support retroactively. Okay, so the next one is the spouse unreasonably deducts expenses from income.
Another common one.
Yes.
Usually for self-employed individuals and those who own corporations or direct shareholders. This is where we call it creative accounting. So I'll say it is what your income for, the Income Tax Act, CRA purposes is not going to be the income that we take at face value just because CRA has accepted it and the government's fine with the income taxes and you don't get reassessed. That's not what we're looking at. we look beyond that. We look at the expenses that you're claiming, whether or not they're reasonable, and there's a long enumerated list about what is reasonable, what isn't reasonable. Like, for example, the most common one are, vehicle expenses.
Yeah.
So, it's unfair to have one party be able to deduct all of these expenses, just, or that are basic to the cost of living, rental expenses, if they're, especially if they're operating out of their own home,
Yeah.
and then their travel expenses, which is really just to and from their work, which is the same expense that, a support recipient would have. So in our situation, it would be unfair to just arbitrarily be able to deduct that, but not give that same credit to the other individual.
Yeah. I think you've pretty much covered that. Okay. The next one is the spouse derives a significant portion of income from dividends, capital gains, or other sources that are taxed at a lower rate than employment or business income, or from tax exempt sources, I guess. So why? I'll tackle this. I'll tackle this one. So if you're the reason why income may be imputed to you under these circumstances is it just comes back to taxes, really, and maybe we should have discussed this at the same time we were talking about the significantly lower taxes outside of Canada or whatever. But when you're receiving, if it's eligible, without turning this into some kind of income tax class, dividends and capital gains can potentially be taxed at a different rate than employment income. And so if you're so I'm going to let me just throw numbers again because I find it's easier for me to describe things that way. If you make $100,000 in capital gains income, you only 50% of that could get taxed. But if you make $100,000 in what's it called, employment income, the entire 100,000 gets taxed. So you can see why it's reasonable to have income imputed to someone in those cases. Also, if you have a business and the business is retaining a lot of income and you're just drawing maybe just a little bit to meet your most basic daily needs, well, you might be paying, I don't know what it is, I'm not sure what it is anymore these days. I think it's about 20% for corporation taxes. So if you think about that, 20% on say $100,000 versus someone that might be, at 30-40%, that difference is significant and would be helpful to a child. So if that's the case, then your income could be imputed. And this is one reason why people, in the family law context, people get frustrated. And it's like, well, I've given you my notice of assessment, and why can't you get all the information? And yes, sometimes it's on the notice of assessment, but sometimes we just want to see a little bit more, with capital gains where there are losses, for example, that were offset against those gains. Your dividends, if we just see dividends, it might not tell the full story. Maybe it's ineligible dividends and maybe it's taxed at a different rate and things like that. So the income tax returns would usually show that. And but bottom line is you might find income being imputed to you through no fault of yours, but just because you're making your income in a very smart and tax efficient way. So, the last one we're going to talk about is the spouse is a beneficiary under a trust and is or will be in receipt of income or other benefits from the trust. And this, again, this is not one that I've actually I don't remember if I've ever had to work with this. So Sherine's nodding. It's something that we've had to deal with. So, oh yes, now I do remember. Okay, so it still all comes down to sort of the sources of income, the taxes that can be applied towards that income, the kind of level of control you have on some of these incomes, and how you're able to deduct expenses that might be reasonable for tax purposes, but might not necessarily give a true picture of the funds that are available to you to pay support. So those are some examples. Now that's what's enumerated. Obviously, if something is close to these reasons, it will fall under the head of imputing income. And so if you're a support recipient and you think that just going by what your spouse or ex was saying about their income is not appropriate in your case, then do know that imputing income is something. Now there's Sherine's favorite times of or reason for imputing income is cash income. When she just hears certain professions and she hears cash, it's like, yes, impute income. So that's not obviously not one of the enumerated factors under the act, but as you can tell, it could fall under any one of that on one of these reasons, right? You could easily, it's tax free for one. Yeah, so I guess actually we could just call it it's tax exempt.
Another one that kind of may fall under here is if you're consistently receiving a sum of money from, like, let's say your parents, let's say it's every $2,000 you get monthly, that income might be imputed to you and be considered income for support purposes. So parents, be careful.
I know, and if Sherine's working against you, I can also see her saying, well, we know the parents gave you $2,000 a month and it's $24,000 a year, but it's tax free. So I want to gross up that amount and make your support even more. So watch out, guys. But anyway, that's all we could, we just want to say be careful. The income, we know the income tax doesn't always tell the whole story. So there are circumstances where imputed income would be appropriate. And if you're someone that income is being imputed to you, that's fine. Talk to us. We might, if it doesn't make sense in your circumstances, we will, make that clear to the other side and kind of clear things. If it's reasonable, we would let you, we like letting people pick their battles, right? If we think ultimately all the signs point to income being properly imputed, then would also help negotiate a reasonable amount out of that. So I'm not sure you have anything else you want to add on this subject.
No, I think that covers everything.
All right, guys, it's been a pleasure, and until next time, bye for now.
Bye.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.